Mosques from 14th, 15th, 16th centuries won't have sale deeds. SC seeks clarification on Waqf by user. The Supreme Court on Wednesday sought clarification from the Centre on the removal of Waqf by user, as it began hearing a batch of petitions challenging the constitutional validity of the Waqf Amendment Act, 2025. Waqf by user refers to a type of waqf when a property is used for religious or charitable purposes for a long period of time, even without formal documentation such as ownership or sale deed. These properties include mosques, graveyards, and other religious sites. The previous version of the Waqf Amendment Bill abolished the concept, but the latest act retains the legal doctrine for historical cases and prohibits its application to future land claims. The Supreme Court asked the central government how Waqf by user can be disallowed, as many will not have requisite documents to get such waqfs registered. It pointed out that most mosques from the 14th, 15th, or 16th centuries will not have sale deeds, and requiring them to provide registered deeds would be impossible. Most masjids would be Waqf by user, said the bench comprising Chief Justice Sanjeev Khanna and Justices Sanjay Kumar and K.V. Vishwanathan. How will you register such waqfs by user? What documents will they have? It will lead to undoing something. Yes, there is some misuse. But there are genuine ones also. I have gone through Privy Council judgments also. Waqf by user is recognized. If you undo it, then it will be a problem. Legislature cannot declare a judgment, order, or decree as void. You can only take the basis. Also read what is Article 26 and how did it become a talking point on day one of Supreme Court's Waqf hearing. Appearing for the Centre, Solicitor General of India Tushar Mehta said while it is accepted that Waqf by user is misused, there are also genuine cases. He argued what prevented the mosques from getting registered. Stressing that Waqf by user is essential, the SC questioned what will happen if the government claims these lands as its own. Mehta said existing Waqf by user, registered before the 2025 Act was enforced, will remain Waqf but not for unregistered properties unless they were disputed. Why will it not remain a Waqf property? Let the civil court decide that, CJI Khanna responded. To this, Mehta responded there are judgments that say the government as trustee can regulate them. If any question arises if the property is government property, the collector will determine. Why this provision? No one can dispute government property, as it cannot be anything but government property. The top court, however, proposed to order that the properties declared as Waqf, including Waqf by user, will not be denotified, but the Centre opposed the suggestion and sought a hearing before such a directive. The properties declared by courts as Waqfs should not be denotified as Waqfs, whether they are by Waqf user or Waqf by deed, while the court is hearing the challenge to the Waqf Amendment Act, 2025, the bench said. The bench, which did not issue a formal notice as of now, said it would resume hearing on the petitions at around 2 p.m. on April 17. Mehta further submitted there was a large section of Muslims who did not want to be governed by the Waqf Act. The bench then asked him, are you saying that from now on you will allow Muslims to be part of the Hindu endowment board? Say it openly. The court said when a public trust was declared to be a Waqf 100 or 200 years ago, it could not suddenly be taken over by the Waqf board and declared otherwise. You cannot rewrite the past, the bench said. Also read SC asks Centre if Muslims will be a part of Hindu boards. Government calls Waqf law more inclusive. Senior advocate Kapil Sibal, appearing for the petitioners, referred to the Waqf law and said it was challenging the provision that says only Muslims could create Waqf. He argued that the problem is that the deed will be required for even those Waqf properties created 300 years ago. How can the state decide whether, and how I am a Muslim or not and hence, eligible to create Waqf? He asked. How can the government say only those who are practicing Islam for the last 5 years can create Waqf? Senior advocate Abhishek Singhvi, who represented some of the petitioners, submitted that Waqf Act would have all India ramifications and pleas should not be referred to the High Court. Another senior lawyer Huzfa Ahmadi, opposing the act, said Waqf by user was an established practice of Islam and could not be taken away. When the court asked Sibal what is wrong about not allowing Waqf to be created without Waqf deed, Sibal said I can create Waqf by user. It's my property, if I want it to be used in a manner. What's the issue? Swipe left for next video to this. The bench said you can register a Waqf as well because that will help. How's that not beneficial? Dedicating to the Almighty is a concept of Waqf. So, the section says to have a deed to avoid bogus claims. With inputs from Ananya Bhatnagar, PTI latest blogs.